Good morning, everyone, and welcome to another special webinar from TPN Credit Bureau. Just a quick apologies to everyone. We know load shedding has been such a nightmare, so traffic and load shedding and everything. We're starting a little bit late this morning, but thank you for braving the load shedding traffic to be with us here today. We are so excited to have a very special guest with us today. We have the Acting CEO of the Property Practitioners Regulatory Authority, Deli Nkambule. Welcome, Deli. Thank you so much for agreeing to be with us today and having this webinar with us.
Thank you so much for the invite. We really appreciate the platform.
Fantastic. And then also joined with us today is our favorite legal lady, Silna Steyn, Managing Director of SSLR. Thank you. We also appreciate you being here today as well,
It's
Silna.
a pleasure. Thanks, Roy, but you can't say that because you have two lawyers on the couch today.
Actually,
so you're not allowed to say
favorite legal
lawyer
lady.
Usually, Deli, I'm allowed to be the favorite lawyer, but today you can have mine. She can have my spot.
That's very, there we go. We're all sharing today. I like it. I am also legal counsel here at TPN, Rowan Terry, and joined off screen is our Ashley Laurent, who will be facilitating the webinar with us, also legal counsel. So in this room today, we have got a lot of legal people.
Exclusively lawyers in one room.
I'm
worried. I'm actually worried. As long as we don't have a fight, guys.
Yeah, we'll all get along.
That's not going to happen.
Exactly. So very excited to get started with the webinar. However, just quickly, a few housekeeping rules. First of all, please make sure that you are logged onto your YouTube channel so that you can participate in our live chat. I know and understand there's going to be a lot of questions today for Deli and for all of us here. So please make sure that you are logged on. You can pop your questions in the live chat. Ashley will be facilitating off screen there, and we will have a short Q&A session at the end of the webinar. I do understand there will be a lot of questions, so if there are any unanswered questions by the end of the webinar, TPN will make sure that we do provide answers to everyone's questions that remain unanswered. Then, if we are looking a little bit blurry to you today, please just click on the cog icon in the bottom right-hand corner of your screen and set your video quality to 720p or higher. Also, there will be a feedback form that will be sent out throughout the webinar. Please make sure that you've completed that and send it back. You can pop your questions in the comments there in case yours don't get answered so that we can provide all those answers through to you. Fantastic. Deli, first of all, just thank you so much for coming to be with us today. I do understand the transition process from the EAAB to the PPRA has been a difficult one, but as such with any major change. We really appreciate you agreeing to come with us and engage with the industry on how this transition has been. So I think just to start off, could you just give us a bit of insight into how the transition has been over the past couple of months?
Well, it's, as you say, it has not been an easy one, but I think we knew about the transition for quite some time. Yes. Technically or system-wise, we were not ready in terms of the onboarding of the new property practitioners. Okay. And you can understand it's a wide pool of property practitioners that we are now supposed to be regulating. And each of these have their own different requirements in terms of the educational requirements, in terms of the registration requirements. So we have been actively consulting with these so that we get to understand how we are going to register them. I mean, currently we register people with just matric because we were only concentrating on estate agents. Yes. But you know, you speak of your auctioneers, that sector is vastly qualified, and they're not accepting matric as an entry level. So it has been very difficult, but however, I am confident as the PPRA, we will be able to successfully do what we have to do in order to transition successfully.
Fantastic. I think that's great. And it is such a huge change. It's not just a quick overnight things going to change and there we go. We wake up the next day and off we go.
And so many questions. I know personally, Deli, and I must commend you on that. Shame, I know I'm one of the people that drive you absolutely crazy on behalf of the industry. Because my clients typically contact me, they have a new idea, a new venture, and they want to know if they would qualify or if they fall under the definition of a property practitioner. And I'm sure we're going to talk about that still, but as much as I can interpret the Act. Obviously, it's easier to know how the PPRA is looking at it. And here I must say, Deli, and I promise I won't make an example of this and make your life even more complicated. But if I message you during the day, you get back to me at 9, 10 in the evening, and you still apologize for getting back so late. And I'm thinking, goodness, you must have so many things that you are dealing with, and yet you make time to engage with the industry. So even just getting started, I can see the intention that you have in answering the questions, in getting out. So thank you for answering my messages at the most unfortunate hours of the day. I really appreciate it, and I believe the industry does appreciate that as well.
Absolutely. So yeah, with the transition that's happened so far, it's been a couple of months now. It's been, like you said, a difficult road. What is your vision for the PPRA, and how your industry is going to best serve how your organization is going to best serve the industry?
I think one of the most critical things that we would like to see now is that every property practitioner that we regulate has a Fidelity Fund certificate as per the legislation. And secondly, what we are looking at is the finalization of the new educational requirements, so that we are all on board and we can do away with the old qualification requirements, your NQF4 and NQF5. We know how the industry has been very vocal against it, and especially because it's quite cumbersome. So we are, as the PPRA, hoping that we can finalize those issues and move forward. So yeah, I think for us it's basically wanting to ensure that we have a professionalized industry. We also have one of the mandates of transforming the industry, so we want to ensure that we transform the industry so that it's reflective of the demographics of the society in which we live in. And more than anything else, we have a mandate to protect the consumer. So as much as we are regulating property practitioners, we also have a mandate to protect the consumers. You know what, in the interpretation of the legislation, there are gaps that are there, but I believe that all of us, including the industry, will be able to fill in those gaps. Yes, some of the people I know are unclear about certain provisions of the legislation, but as the PPRA, we are there to assist in interpreting the legislation, and where, as well as the PPRA are unclear about it, we will seek legal opinion so that we come to an understanding of the definition, that will be understood by everyone, and not only us as the PPRA, as the regulator.
And you've shown your willingness to engage with industry and with people from the industry, attorneys like myself and the attorneys from TPN, engaging in interpretation. And I think that's something that's desperately needed in the industry, to have a clear one voice coming to the consumer. It's so crucial. If we have different opinions, different interpretations, it causes chaos to the consumer, and we look quite silly in the industry. So thank you for engaging. I think one voice is absolutely crucial.
100%, and I think the best way forward is if we all work together. We all want this desired outcome. So let's all work together, and thank you for coming on. So really appreciate this so much.
Thank you.
You mentioned earlier educational requirements, and I know there's a lot of questions about that out there. So I just wanted to ask if you could maybe provide some clarity with regards to the requirements that property practitioners must meet in respect of their PDE and NQF qualifications. I know that's quite a vast question.
Well, I think,
but we can take through it slowly so everyone.
Well, I think the old requirements are still in place. So you need to do your NQF4, then your PDE4. You need to do your NQF5 and your PDE5. It's still in place until we then come up with the new educational requirements. What the regulations are saying is that we need to consult with the relevant industry bodies so that we can come up with new qualification standard, new educational requirements, new materials, course materials. And that is exactly the path that we are at now. We are busy with the consultations with all the industry, and that process is underway. And as soon as it's finalized, we'll then come up with the new educational requirements that will be applicable to the entire industry. But for now,
Fantastic.
the old ones are still in place until we come up with the new one, because we cannot have a gap where we don't have any educational requirements in place.
Absolutely, 100%. Then just on the NQF4 qualification, a question that pops up is it still a requirement to submit a logbook?
Yeah, it is still a requirement based on the fact that the old qualifications are still in place. So the logbook is still a requirement until, as I've stated, we then change.
Yes.
But for now, it's still a requirement.
Fantastic. And that change with the new educational requirements, that's not going to be anytime soon. It's still quite a long process to go through.
You know what, we are hoping that we'll be able to come up with something before the end of the year. I'm not sure when it's going to be implemented, but I think the discussions with the industry are already at an advanced stage. We've had several meetings with them. Great. And we are trying our best to ensure that by the end of this year we at least have something in place, and then we will look at the implementation part. When are we then going to implement?
That's fantastic. That is not the answer I was expecting at all. I was, it's a long and difficult process. So it shows you guys are doing the work, you are doing the research.
That's why poor Deli works so late.
Yeah, that's why she's messaging you at 10 o'clock at night.
I think the industry has been helpful themselves, because what we did, we put them together in one room and we said, within your industry, what do you have? What training do you provide?
Yeah.
So we're not trying to reinvent the wheel. We are taking what they have and putting it together. That's because remember, it's going to be different qualification requirements for each separate industry. Yes. So we know that some have their qualification even accredited by the SITA. So there's no need for us to reinvent the wheel. It's just to bring it together and then we can move on from there. So I think that, yes, it's a long process, but we think that because of the fact that some of the industry are already advanced, we might shorten it.
Oh, brilliant. That's fantastic. Yes, because I know obviously the guys from Ribos, AISA are very actively involved. Yeah. And I think it's a really good thing that everybody gets in. I know, I'm going to hijack you here. Off screen, I promise, to talk about the rental agent who obviously has my heart in this industry. And I think it's brilliant. I do believe we have to relook the way training was done. For, again, the rental agents,
Absolutely.
I think everybody was so well trained on sales side and how that works. But rentals has always been the stepchild, but don't worry, I am the stepmother, so I'll make sure I treat you very well in the industry. So things like that, you're open to that, and the industry does appreciate that.
Definitely.
So that does actually bring me to my next question here, which was can the process to obtain your relevant PDE or NQF qualifications, can that be streamlined, or is it just not possible at this stage? But I think you have touched on that already by saying, look, you're trying to not reinvent the wheel, but change it a little bit to going forward, hopefully by the end of the year.
Yeah, you know what? The current one, we can do nothing about it. And I think it will be a waste of time for us to concentrate on trying to streamline the current one when we are developing new educational requirements. So what we need to concentrate on is the process that we are currently engaging in, so that we can have these new educational requirements that will be applicable to all the industries, the different industries. And Selna touches on an important point that previously we were concentrating on sales, we had managing agents, but if you look at our educational requirements, they didn't really provide much about managing agents. This time around, each and every industry will have its own educational requirements, so that's what we're striving for. So if you're talking about the rental sector, they will also have their own, so that they are not directed to do your sales educational requirements on sales only. Yes. So that's what we are trying to do as the PPRA.
That's fantastic.
It just really is awesome. Then just with exemptions, so people are able to apply for exemptions from the provisions of the PPA. Could you just give us a few of these exemptions and what these mean for those individuals?
Okay, so in the current legislation, and we're excited about it, we've got a Section 4 which it allows any person to apply for an exemption from complying with the provisions of the Act. And what we have seen is that, for example, we have seen one of the industries that we have granted is your mortgage originators. They have requested to be exempted, and we have exempted them based on their application for a period of 3 years, obviously. So there are different reasons why you would. In fact, what the Act says, what the provision says, is you can be exempted from any provisions of the legislation. So you would make the application, we consider the application, if the grounds are valid, we will give you an exemption based on your request.
Perfect.
That's very interesting. Sorry if I can jump in on
100%,
that.
please.
The timelines, because I'm aware of the fact that, especially on the mortgage originators, it was relatively recent. Obviously, it couldn't have been more than 6 months ago that PPRA was only formed in Feb. It seems to be a relatively quick process. Sorry, it's a very specific question, but how long does that exemption process typically take? Because this must have been quite quick for the mortgage originators.
Yeah, it's actually, in terms of the Act, we're supposed to have looked at your application and responded within 30 days. So that's the statutory requirement. It's 30 days.
30 days.
Sure. That's amazing.
That's a quick turnaround time.
Yeah.
And then also, just with regards to if you have to deny any applications or exemption applications, is there any appeal process, or is this decision final?
No. There is an appeal process,
Fantastic.
and I think currently, so far, we've not denied anyone, and but there is an appeal process. You can appeal if you're not happy with the decision of the authority in denying you their exemption.
Perfect. That's fantastic. And then also, recently, the PPRA released the notification in respect of property practitioners aged 60 years and above. Could you just explain a bit more about this exemption, and what does it mean now for now that the exemption is no longer applicable for property practitioners over the age of 60?
Yeah. I think that what the PPRA is trying to do is ensure that instead of busy giving people time periods within which to comply with the legislation and not implementing those. So what we've done, we have had situations where we've asked people to comply with the legislation, and especially the educational requirements, and we've kept on postponing, and we've never implemented. And we've realized that the more we do that, people don't comply because they know that we are going to keep extending.
Yes.
So in relation to the over 60s, what happened is that people that were over 60 would make an application, and then they would come and sit for an oral examination, and we would then exempt them based on the age. That they are 60 from complying with some of the educational requirements. But we've had that for a very long time, and we are now saying that people should comply with the educational requirements.
Yeah.
We are looking for an industry that is professionalized, and if we are going to have a professionalized industry, then everyone must comply with the educational requirements. So that is why we have done away with the that education and that over 60 exemption, and we are saying that people should come forward and make sure that they comply.
Absolutely. And is there a deadline for this particular?
It's January. I think it's January not sure of the date, but it's next year, January.
Next year, okay, fantastic.
And it actually makes sense. I mean, a lot of people make career changes at sort of that age. I mean, you're only in your middle of your life by about 60. It's a perfect time to change. My
Zolda
ideas
likes
about...
to believe she's living until 120.
It's going to be, don't worry, industry, I'll be there until I'm 120. We'll have these conversations. Deli, you're going to be there, right?
Yes.
Until 120.
Definitely.
So to make a career change at 60, it makes sense. The decisions that I'm seeing coming out of the PPRA makes logical sense to me. So I'm sorry if I offended anybody now on that one, but I actually do really mean, I think it's fantastic if you make a career change at 60.
Yes.
But then we need to be professional. We can't just age. I'm all for, with age comes wisdom. But with wisdom doesn't necessarily comes the exact knowledge of a specific industry. So I understand that. It does make a lot of sense to me.
No, absolutely. Thank you for all those questions. Next is the FFCs.
I'm going to drink water now.
take a deep breath. So one of the questions we get a lot is, what is the process to obtain one's FFC and the required documentation to accompany this application?
So it's a simple process, as long as you have the compliant, documents. For a new applicant, what we require is a letter from your employer confirming that you are employed by the specific company.
Okay.
It must be signed, dated, and it must mention who your mentor is. And then we require the relevant, application fee. So that's as simple as that. If you've got that, then we register you. But however, your application is dependent on the fact that your company, the company that you want to be linked with, is compliant. Okay. If it's non-compliant, your FFC is not going to be issued.
Absolutely.
But it's a simple process. And if everything is in place in relation to the company that you want to be linked with, it is very simple process. Just a letter. We also require a copy of your ID, a certified copy of your ID, obviously.
That's obviously just to confirm. And then just for clarity's sake as well, who needs to obtain an FFC whilst working in the property industry? I think this comes to Silna's question of definition of a property practitioner. Where does the line get drawn?
Okay. I think we've tried to explain this, and I think it's a debate that we'll continue to have as the industry, because we do believe that some people believe that they're not required to obtain an FFC. But as the PPRA, we want to continue to have this engagement so that we are all in the same understanding. Yeah. So the Act is clear in terms of Section 1. You must be operating as a property practitioner, either in terms of a sale or lease on behalf of someone else, and you must be earning a commission for that transaction that you are engaged in. It's as simple as that. But I know that when you read the Act, it defines it more broadly, and we would have to go into that definition. But simply, it's a third party. For example, there must be a seller, a seller, a buyer, and then a property practitioner, who is assisting these two parties come into to conclude a transaction. And for that, he gets obviously a commission.
Some kind of compensation. Okay.
Can I ask an FFC question? This is look at me now being the industry voice. I can see the questions flying typically to my side. And if it's a silly question, just tell me it's silly and we'll move on. But the FFC is currently coming out. Some of them are until 2024, some until 2025. Now, I get this question. I know an FFC at this stage should be for a period of 3 years. Is it about when an audit was done or when it was submitted? What is the situation with the time periods? But remember, lawyer accounting for me is a little tricky. So logically for me, it would have been 3 years from date of issue. What is the position on time periods for FFCs? Yeah,
I think there has been a confusion, and we are happy to clarify it. We have, if you're doing your renewal, so your renewal, it starts from July, and you're renewing for next year. So which means your FFC is going to be valid as from 2023. So it's 2023, 2024, and 2025. However, if you apply for an FFC this year and it's not a renewal, it's a new FFC, then your FFC will be valid until 2024, because the FFC starts counting on the date on which it's issued. But if it's a renewal, then your renewal starts counting from next year, because you already have an FFC for this year.
It makes sense. I was thinking it's something, because it's very similar to the LPC FFCs. So that's why I think it made a bit more sense to me. I suspected it's a June, it's a July counting situation, but I just wanted for industry state clarify that one, because I know that's causing massive
it's basically questions. For which year you are applying for. If you are applying from next year, then it's going to be 2025. But if your FFC is being applied for from this year, then it's going to be 2024.
It makes sense. Yes, even lawyer mathematics for me makes sense on that one.
And then just with also just who needs to obtain, administration people within a company who also are dealing with, would they require an FFC as well? So admin people, I know a lot of this question comes up to say, look, I don't actually deal with the seller or the buyer directly, but I'm just working here behind the scenes. I just fill out, I dot the I's and cross the T's.
If they are going to deal with the lease agreements, then they will have to be issued with an FFC. Yeah. But if they are not going to deal with the lease agreements, the sale agreements, then we don't need to issue them with an FFC.
Fantastic.
And I think something important also to just be aware of as the admin people, to in your email signature or whatever, accidentally make yourself seem like you're an agent and you are fulfilling the functions of a property practitioner. Obviously, it creates confusion to the public, and the PPRA's duty is obviously to protect the consumer as well. So am I right in saying then the admin people must just make sure they clearly identify themselves exclusively as in an admin role rather than making it seem like they might actually fulfill the duties of a property practitioner? Am I right?
I think that's correct, Sona. And one of the things that we've realized about the admin people is they go over and board to then explain to the tenants how much must you pay, what is required, what, in terms, they actually give advice in relation to lease agreements, in relation to the property itself. So when they do that, then for us, they are now acting as property practitioner. But if their job is simply to send out, admin or to do admin work and send out a contract without giving any advice in relation to the contract, then we do not require them to be registered. They must be very careful of the service that they provide.
It's similar to attorneys again. I mean, it feels very similar to the Legal Practice Council. I mean, your secretary. I think industry-wise as well, you would understand if you want advice from an attorney, if you call SSLR and you want advice, a secretary isn't allowed to fulfill the duties of an attorney. You're not allowed to advise. And the same with property practitioners. Makes sense.
True.
Absolutely. I think we have a question just on this topic. So Ash, do we have any?
Yes, absolutely. So we have two questions that I'd like to pose because it's so relevant to the topic. One from Mariette Skuman. Will staff that earn a salary but deal with sellers and buyers have to have a FFC? We'll answer that one and then I'll go to the next one.
Great. Could you just phrase it again?
Will staff that earn a salary but deal with sellers and buyers have to have an FFC?
Yes, they will. I don't know what salary they are talking about, but as soon as they go into the field or seller and buyer and also giving advice, then they will have to have an FFC. I know that the industry has been trying to say, no, I earn a salary, I don't earn a commission, but look at what the Act says you are doing. Then you must get an FFC.
Fantastic.
Absolutely. And then, so we have another question from Karen Hayes. Are current FFCs, which are issued by the PPRA, valid until the end of 2022, as stated on the certificate?
I'm not sure 2022 from, if the FFC was issued on the 1st of January to the 31st of December 2022, yes, they are valid. So whatever FFC you have is valid until the 31st of December 2022. It's only the FFCs that we've issued after March or April that is now a 3-year FFC.
Great.
Thanks,
awesome.
Guys.
Thanks so much, Ash. Then just quickly, what is the deadline now I think there is a renewal deadline for your FFC. What is that date currently?
So the dates have not changed. So our renewal opens from the 1st of July and up until the 31st of October. And then any renewal done after that, it has a penalty. So the dates have not changed.
Then just quickly on those time periods. So the time period to renew, as you just said, is the 1st of July until the end of October. However, the industry has been told that they'll only be notified if their renewal was successful on the 1st of December 2022. So will practitioners be liable for a fee for the month of November where they aren't really sure, they haven't got their renewal, they don't know what is the stance? Maybe you could just provide some clarity.
I think the communication that we issued out was in relation to when we will be able to deliver all the renewal FFCs that have been applied for, and it does not affect the date on which you must make a renewal. It still stands from the 31st, from the 1st of July up until the 31st of October. But what we are saying is that because of the changes that we have had to go through and the backlog, we are going to make sure that every renewal FFC is issued by that specific date. So the industry must be aware that they are still supposed to comply with the 31st of October.
Great.
However, their FFC, because it's valid from the 1st of January next year, we will be able to issue it before the deadline that we have stated. So it's got nothing to do with when they must apply. It's when we are going to make sure that we've issued
so it's a
every
commitment
FFC.
from your side, not the other way around.
And that is basically because of the backlog that we have. So we know that we're supposed to issue the FFC within, the renewal FFC within 30 days. It has not been possible to issue it within 30 days. So we've given ourselves 60 days, mainly because we wanted to prioritize the new registrations because the renewals are only valid until from the 1st of January 2023.
Do you foresee a potential extension on that date, or is that a dead stop? I know this is a hard one.
Hard question.
No. We don't foresee an extension. We are committed to ensuring that every person who has applied for their renewal FFC is given their FFC within that period of time.
Yeah, but that's a massive commitment. That kudos to you guys for having such a strong start.
I think also
I put you on the spot a little strongly there, but
no, that's fine. I think also it will depend on for example, if you apply for it, remember we've got a 30-day period within which to issue your FFC. So if you apply for it, let's say on the 16th of December, you still have 30 days to issue it. You'll then have to wait for the 16th of January for it to be issued.
Exactly, but the ones now, that's a fantastic commitment. Thank you.
Yeah, thank you so much. So for our last and hot topic for the day, mandatory disclosure forms. So I know, Silna, you can pop in here with all your comments, I'm sure. I think one of the number one questions that we get asked a lot, and it almost as if the question answers itself.
Yes.
Is a mandatory disclosure form compulsory?
Yes.
It's,
Section 67 is the one thing that's very
and
clear.
also mandatory is in the word.
Yes.
So exactly, it's a question that we get asked, and it answers itself.
Yes.
Just with that, what is the PPRA stance with regard to written mandates? Does Section 67 create a necessity for written mandates only?
Yeah. I think it does.
Yeah.
If you look at the section, I think it's subsection 2, it says it must be signed and it must be written.
Yes.
So you can only have something signed and written
if it's on a piece of paper.
If it's on a piece of paper.
And
so that's what we...
Exactly.
Yeah. The mandatory disclosure form must be attached to the mandate and the lease agreement. And this has been my position, and I've said this many times to everybody in the industry. I can't see that the legislator intended something to be attached in a conversation in mid-air. That would be wild if we can do that. And with TPN kind of technology, I can see things like that happening. E-sign on the next level, but we're not there yet. For the moment, my interpretation is definitely a mandate should be in writing. Now, I think a lot of people, actually, I think the conversation is going to go wild there in the comments, but remember, in terms of the Estate Agency Affairs Act, yes, a mandate only had to be in writing if it was a sole mandate. But we're on a new piece of legislation.
Yes.
The Property Practitioners Act is a new thing. It isn't like a revamped copy and paste of the Estate Agency Affairs Act. Yeah. It's a new act, and the intention is to regulate the industry, and our stance, both from SSLR and TPN, on our training over the past more than 5 years. So even prior to discussions, public discussions about the PPA, we've been advising landlords and agents to actually conclude a written mandate. Because the truth is, your commission, just now in a lawyer conversation again, to prove what you've agreed to.
Exactly.
So when it comes to money, guys, let's write down what we agreed to. And my stance on this has always been, yes, if you're worried you're going to lose your listing, you list and you have to wait for a mandate to be signed before you can conclude a lease agreement, you're going to lose your listing to another agent. I appreciate that, but as an industry, it's our obligation to help each other to do that. If everybody is using, and I know the majority of our viewers would be subscribing to the TPN leaseback, and the mandate agreement in terms of the leaseback, obviously with the mandatory disclosure form, part of the documentation, easy enough to complete. If everybody is using the same documentation, we as the industry would stop this situation of landlords or sellers for that matter, but I'm talking specifically rentals here, from one landlord rather going to another agency because he doesn't have to do that much paperwork. It's almost like if you go to an attorney, you wouldn't mind completing documentation. When you go to a doctor, nobody ever asks at a doctor, but what about Poppy? I'm not going to complete my medical history. Suddenly, Poppy has nothing to do with life.
Doesn't exist.
You give everything about your history. And we as an industry have an obligation to professionalize this and make sure, that's a new word. It's like my awesomenize from the previous webinar. But we need to make sure that we are the ones driving that. If there are agents that doesn't have mandatory disclosure forms, doesn't have written mandates, the intention should be from the industry side, well, they're non-compliant. And obviously there would be clients using them, but those clients would become less and less similar to what we've seen with, TPN and non-paying tenants.
Exactly.
It wasn't fun in the beginning for the landlord that listed a non-paying tenant, but now where we are now, we're getting bad tenants out of the equation.
Absolutely.
And it should be that way with written mandates, and we will fight less about commission.
And that's the thing, it's actually getting rid of ambiguity in the industry to say, this is what I said and he said and she said, and now you've got a written mandate.
Definitely.
And as you said earlier, we've got this in our lease packs, it's there. You can go to shop.tpn.co.za, see all of our mandates, it's all in writing. We've SSLR are the drafting attorneys for that, and it's drafted beautifully, if I have to say so myself.
Even me.
So that's exactly it. It's getting rid of this ambiguity and all these fights in the industry because no one actually knows what's going on. If it's there, it's on paper, it's in writing.
Can we talk about an industry fight? Look at me, I'm that one. I'm just throwing the industry fights in today. But one of the biggest things on the mandatory disclosure form that I'm seeing is there's an argument, and it's one of those arguments that I can't see why there's an argument. It's written in the Act very clearly. But there is an argument around mandatory disclosure forms. First of all, being referred to as a condition report, which is not the same thing. The mandatory disclosure form's intention is that the seller or the landlord notifies the property practitioner of anything that has to be disclosed, like, oopsie, this place accidentally doesn't have a ceiling. It's important things. And it's not there to create a problem for you as the property practitioner. The intention of the mandatory disclosure form, and Section 67 is very clear about this, it's to protect you as the property practitioner. When you comply with the legislation, it protects you from personal liability.
Absolutely.
And it's not bringing in personal liability for the property practitioner. It's always been there. You've always had a risk of a delictual claim in acting on behalf of a third party and not disclosing potential defects that could lead to damages. Now the Act is putting an obligation on the landlord, on the seller, to protect you as the property practitioner. But the thing that's happening in the industry is, they confuse it with a condition report. Similar, I suppose, but it's the landlord or the seller's obligation to complete this document that forms part of the regulations, that's part of the lease back. It's not a complex document to complete. It's basically like, does the place have a ceiling? Yes. Does it have a roof? Yes. Is anything falling obviously apart? Yes and no. Or I don't know. Have you climbed into the roof? no, I haven't, it's okay, but then at least disclose that you're not aware of that.
Yes.
I advise getting third-party inspectors to do that, and you have a good quality document. But does it relate to leases? The Act, in my opinion, is very clear, but I wanted a Deli answer on this one.
That's actually Silma's just taken over hosting this webinar, because that's my next question. You've answered 2 of my questions already. So, Deli,
sorry,
if you
can...
I'm having so much fun on this. The Act is clear. It also relates to lease agreements. If you look at Section 67, I think it's 3 or 2, it says both the seller and the lessor must complete the disclosure form. Yeah. So it doesn't only relate to sales, even in terms of lease agreements, it must be completed.
Yes. Absolutely. Then also, just like we were saying earlier, what are the repercussions of selling a property or renting a property without a signed mandatory disclosure form?
Yeah, I think the Act is clear. For the property practitioner, we as the PPRA can impose a fine, and if you look at the schedule of fines, we can impose a fine up to 15,000. Or if we feel that we should take that matter before an adjudication committee, we'll definitely take it before an adjudication committee. And then also, it does not end there. Even the buyer can take the property practitioner up and hold the property practitioner liable for the damages that they have suffered. So it's 2 ways. The PPRA can discipline the agent, and the buyer as well can claim against the agent. So it is important that property practitioners ensure that sellers and lessors, they sign the mandatory disclosure form. Like as Sona said, it protects them as property practitioners from being held accountable by the PPRA as well as the lessor, the buyer.
Absolutely. Then also just a few questions here. Just if owners live far away from the property and they can't inspect the property themselves, can the property practitioner complete and sign the document as the mandated practitioner?
Absolutely not. You can't do that, and the Act is clear. It's the responsibility of the seller and the lessor. And if the seller cannot do that, they can hire a professional person to do that on their behalf.
Fantastic.
And at least the property practitioner is not held responsible for even the report from the professional person.
Yes.
It will still be the lessor and the seller that will still be liable. But the property practitioner should not, and they must avoid doing that on behalf of any person.
Yes.
They should not complete a disclosure form.
Deli, recommending a third-party inspector, say for instance, you said with a property practitioner, the guy hasn't even been in South Africa, it's not even a South African citizen. To recommend a property, an inspector, and even do the arrangements, would that suffice, provided that the landlord or the seller actively instructs the inspector, the property practitioner? Would they be allowed to assist in facilitating the inspection?
Yes. I think for me, the property practitioner must try as far as possible and stay away from being involved in even instructing the third party. The seller and the lessor must do it on their behalf. And what the property practitioner can do is that after they get the report, and the seller and lessor is satisfied with the report that has been issued by the third party, they can then transmit it to the buyer. But we would recommend that the property practitioner keep away from involving themselves in that type of transaction.
Yeah, I think that's something very important to be aware of.
Absolutely. That's actually brought on to my next question, which is, does the owner need to utilize the services of architects, inspectors, contractors to inspect the property?
They can. Absolutely. I think they can, and it would be for you as the seller. You are able to even prove that you hired professional people to look at the property, to investigate whether there are any defects in the property, and whatever you would the report you would then get from those professional people, you would rely on. I mean, even if they took you to court, you would able to say, I hired a professional person to assist me with checking my property, and this is the report. It's perfectly allowed.
And I mean, as a property investor, this is your investment.
Exactly.
I'm always flabbergasted when, I mean, you know, I work closely with most of the property practitioners. I am honored to, thank you. But I'm always flabbergasted with big investors, and the questions are always, but this is a very big investor. He has a big portfolio. He doesn't have time for this. And I'm thinking, that is your business. We must educate property investors as well around giving a good quality product. You're going to get probably a better rent, a better price if you spend the extra time on your property.
Exactly. Well, that brings the end to our formal part of the webinar. Now we're going to have a little bit more fun. Ashley, we've got quite a few questions, I'm sure.
We do.
Okay, if you just want to take us away.
We do. Guys, I'm going to start with the last topic we dealt with, mandatory disclosure forms, and then we'll work our way back. Okay, so our first question is from Rolene Nivanaisen. Who must complete the mandatory disclosure form if we do a renewal of a contract now? Who completes the form?
I think the act is clear. It's the lessor and the seller. They must complete it. The property practitioner must stay away from.
But if it's on a renewal, Deli, that's a fantastic question. On a renewal, the act is clear that the mandatory disclosure form must be completed at the time of mandate. So say, for instance, let's talk rentals now, as I always do. But so you have a written mandate agreement. Your mandate relates to this particular lease agreement that you have. So on a renewal, same landlord, same tenant. Is the mandatory disclosure form even required? Because the mandate was linked to the lease agreement, so the renewal, the same mandate agreement will extend into the renewal. Would the mandatory disclosure form be required there? Or, as he was attached to the one mandate, isn't he sufficient even into a renewal?
I think it is sufficient if it's a renewal, as long as it's not a new tenant, it is sufficient. But also I would recommend that the property practitioner, if your lessor is still willing to go back and sign another one, so be it. Ask your lessor to sign another one so that you protect yourself. But I would think that the old one would suffice.
As long as it's the same mandate.
It's the same, it's the same tenant as well.
Yes. And I think it's important to realize that your mandatory disclosure form links to your mandate. So it's about the relationship between the landlord and the property practitioner, or the seller and the property practitioner, obviously to the protection and benefit of the purchaser or the tenant, but it links to your mandate. So it doesn't have that much to do. It does have a lot to do with your lease agreement or your sales agreement, but your trigger is mandate, not lease.
But I think, Selna, what happens is that if you have a new tenant, remember the old tenant would have used the property, and things might have gone wrong within the property. You need a new disclosure form because it's a new.
It would be a new mandate.
You would need another disclosure form.
A new tenant, because a tenant can change a property a little. Tenants we love you, but they do change the condition a little.
There's a couple questions regarding the fact that property practitioners are aware that they need to have these completed mandatory disclosure forms, but what happens if a landlord refuses to sign the disclosure form, or they don't get the documentation back? There's a lot of concern regarding landlords refusing to sign. So what is the best approach for property practitioners in this regard?
It's not to take that mandate at all, because there is a requirement. It's obligatory by the Act that seller or lessor must sign the mandatory disclosure form. So if they don't, as a property practitioner, you simply have to walk away from that transaction.
It's like FICA. I mean, if a landlord doesn't want a FICA or a seller doesn't want to do FICA,
you can't enter into that transaction.
You can't. So it's their loss, because they lose a property practitioner to act on their behalf, and they will do the inspections and all those fun little things about the geysers leaking themselves.
And then not necessarily on mandatory disclosure forms, but Tuli Masilela asks, What about open mandates? Should they also be in writing?
They should be. We believe that anything that has to do with the mandate this time around has to be in writing.
Yeah.
Yes, I agree with that.
And then
Passionately. I'm unpopular for this view, but it's the correct view.
Yeah, it is the correct view.
Okay. Then there's one from Tanith Bauer. Does the mandatory disclosure form apply to new developments? So, I don't know if...
You know what? I think the Act does not specifically say that the disclosure form is in relation to an old property.
Yeah.
It says that if there is that transaction where you are going to lease or sell property, you must have a mandatory disclosure form. So it's not linked to the age of the property, it's linked to the transaction that you are entering into. So yes, even if it's a new development, we've seen a lot of new developments that have that where the person is in the property and there are cracks and everything that is there. So it's a requirement, even if it's a new development.
Exactly, and I think it goes to that confusion between mandatory disclosure form and condition report.
Yes.
But I mean, snag lists are in new developments are the source of a lot of litigation.
Yes.
So a new development, to your point, is usually a bit more problematic, or could be a bit more problematic than a property that you've known for some time.
Guys, then I'm going to jump to FFCs. Quite a couple questions on FFCs.
Great.
So the first one is, and Deli, maybe you want to just touch on this again. I think there's a lot of people asking in different scenarios who must apply for FFCs, assistants, canvassers, property managers, the sorts. Don't you want to just reiterate for our property practitioners watching today what the position is in this regard?
Okay, so in terms of the Act, I'll just try and give some of the property practitioners that have to be registered. Your managing agents have to be registered. Your bond brokers, you have to be registered. Your normal estate agents that we're registering, your developers insofar as they act as property practitioners, your auctioneers as well, they have to be registered. We've also got those people that are dealing with timeshares, they must also be registered. So, I know that there's that confusion regarding just explaining or defining who has to be registered. And it creates a lot of problems because people come up with different scenarios. I do this, I don't do that.
Yeah.
But we are only able to explain to you when you really explain to us what you do, and we will then refer you to the provision in the Act that compels you to be registered. So I think that conversation is going to be a conversation that as the PPRA we want to continue to have, so that people are clear as to who has to be registered and who does not have to have an FFC.
Then we've got a question. With the FFC being renewed every 3 years, is the understanding that an intern is expected to complete the internship within the 2-year period from registration? And if so, would they be expected to renew as a full status agent after year 2, or will they be issued an FFC as a full status agent after year 2?
Yes. Once they have qualified, remember that unfortunately the FFC, the period of the FFC doesn't take into account the fact that you, as an intern, you are supposed to qualify within 2 years. It gives you a 3-year FFC. And then if you do qualify in 2 years, you must then come back and we'll give you a full status as FFC.
And then just 2 questions on the Fidelity Fund. So Louisa Janssen van Rensburg has asked, can the public still lodge a claim with the PPRA against the Fidelity Fund?
Yes, they can. But remember, under this new Act, the property practitioner must have been registered with the PPRA. So you cannot, as previously under the Estate Agency Affairs Act, lodge a claim with the PPRA or under the Fidelity Fund if the property practitioner was not registered. And that's one of the very big changes that this Act has done. It's saying you are only benefiting insofar as you contribute to the Fidelity Fund. I mean, even with attorneys, if you're not registered with them, you can't benefit from a fund to which you don't contribute. So that is what has happened also with the Fidelity Fund.
And
for
again,
the PPRA.
protection consumer-wise for the landlords that doesn't want to sign mandatory disclosure forms to have a property practitioner registered with the PPRA, they don't have protection. And if they decide to contract with an agent that's not a registered property practitioner, they run the risk, a massive financial risk. So I think that has to be a message into the consumers as well.
Quick one on exemptions. How would you go about applying for an exemption? This question is from Karen Melville.
Okay, so there is an application form. It's on the website. It asks for certain details from yourself. For example, you must give us the reasons why you're asking for an exemption. And also we require certain documentation that must be attached to the application. We also tell you the time periods within which we'll be able to come back to you. So it's a matter of downloading the application form, completing it, and emailing it back to the email address on the form.
Okay, great. And then just with respect to exemptions, Edna Brink asks, if you have an exemption already 10 years ago, is this still valid?
That would be an educational exemption. Yes.
We can ask Edna to just clarify on that regard, but that was her question.
Yeah, I think that would be an educational exemption, because the exemption in terms of Section 4 just recently started. So I'm assuming that person is speaking to the educational exemptions that we grant to estate agents. Yes, that would still be applicable.
Okay, great. And then just in respect of NQFs and education, a lot of people are asking, sorry, it's just slipped me here. Will current education status still be valid, or will we have to review on the new material when available? So I think a lot of people are asking, is, if there's a question on current education status, is this still valid? Or will they have to redo it?
Hi guys, sorry about that. We're having some technical difficulties. I swear we will never escape load shedding. Ashley, will you just repeat the last question we had?
Yes, it was just in respect of education material. Will current education statuses still be valid? This is from Sarah Hartwig. Or will we have to redo on new material when the PPRA makes this available?
Makes it available.
No. I think if you have attained your qualification, under the current NQF 4 and NQF 5, you don't need to start afresh. Whatever we are developing going forward is going to be applicable to all of those that have not qualified.
Not qualified as
so if you're already qualified, you're safe.
I think there's a massive sigh of relief across South Africa
you are
right
safe.
now.
You don't need to start afresh.
I could hear it.
That's great.
You won't need to start afresh.
Ash, I think if we have a few more.
Yes, so we've got a lot of people asking on turnaround times from the PPRA with respects to applying for FFCs and also asking specific queries. They feel that it hasn't necessarily been addressed. How do they go about this, Deli, if their questions are not being answered or queries are not being addressed?
That is one of the constant problems that we are constantly having at the PPRA. But maybe just in terms of turnaround times, if it's an FFC, it's supposed to be 30 days. Your FFC has to be issued within 30 days, especially if it's a new application. If it's a renewal, we've extended the deadline just so that we can deal with the new applications. And where people have queries and have not received progress, I would request that they contact our call center so that they can find out progress in relation to their applications. But most of the time, I think the problem is caused by the fact that we have non-compliant applications, and then there's just some communication breakdown where when we go back to the client and inform them of the documents that are non-compliant and them having to return back the compliant documents, then there's a lot of time that takes place just between that, and we know that it causes frustration and delays on part of the clients, but we would encourage them to contact our contact center.
Great. I think we've also put that on the screen as well for everyone throughout the webinar, so just use those contact details. And then Ash, I think we have time for one more question.
One very last question, just on logbooks. Could you clarify the position again on logbooks, and then interns, must they wait a year before submitting their logbooks, or can they submit after 3 months with the new act in place?
The current educational requirements stand. So logbooks are still required, and also they only have to be submitted after 12 months. However, when we have the new educational requirements, that might change. In fact, the industry is even proposing doing away with the logbook, and that is what we are looking at. And as soon as we have the new educational requirements, we will be able to communicate whether the logbook remains or whether there is something that is put in place in terms of a logbook, because the logbook is just to assist us as the PPRA to ensure that you have been doing what you are required to do within the industry. It's your POE, So if we as the industry agree, we might downscale it, to, I know now it's bulky, we might downscale it to maybe 10 or 20 pages, but it's a discussion that we are having with the industry. If the industry feels that it's not required, we will definitely look at it. But we do feel that there were situations when someone went to work for a property practitioner, and all they did was to make tea, and they did nothing that really showed that they were an estate agent. So we wanted a POE to show that this is what you really did during your internship.
Great, thank you so much, Ash. I'm sure that must have been very difficult to filter the questions. That does bring us to the end of the webinar. Deli, I don't know if you want to have just a few final remarks for the industry just before we close off.
Yeah, I think for us as the PPRA is to say that we are committed to continue discussions with the industry. We are also, wanting to ensure that every property practitioner is issued with a Fidelity Fund certificate timelessly. We are working on our IT systems. We have had challenges with our IT systems, but we are busy working on that. And we just want to assure the industry that we are committed to serving them. And more importantly, we want to ensure that we have a professionalized industry and also ensure that we transform this industry. More importantly, we want to protect the consumer while we regulate those industries.
Fantastic. Deli, thank you so much for coming with us today on this webinar. We've really enjoyed it. I can see Silna's enjoyed it as well.
Thank you.
Silna, also thank you so much. It's always a pleasure to have you on our webinars. And to everyone out there in the industry, have a fantastic Wednesday, and we will see you soon. Thank you.
Thank you, everyone.
Thanks.